Good afternoon, everyone, and welcome to another question and answer session. My name is Samara Belitzky. I'm an employment lawyer at Samfiru Tumarkin in Ottawa. I do assist clients all over Ontario, and as many of you know, our firm assists clients throughout most of the country. We have our offices in BC and in Alberta as well, but I myself do practice law in Ontario. I'm here once again to answer all of your questions about employment law, workplace issues, you name it, I'm here to answer. The hot topic, obviously, on everyone's minds these days is mandatory vaccines and vaccination policies. So I'm sure we'll get a lot of those questions today. And I'm happy to answer all of those because it's, like I said, a hot topic. Lots of people are asking questions about that. But any questions at all, whether it be about severance, constructive dismissals, workplace issues, health and safety, COVID layoffs, regular layoffs, whatever the case may be, issues at work, whatever it is, if you have a question, now is the time, send it in. I'm happy to answer it during the next 30 minutes. If you or your friend has a question, go for it. I'm actually going to get right into it because I see we already have a few questions coming in. So I'll start answering questions right now as they come in. But please feel free to send your question. Now is the time, and I'm here to answer. So don't be shy. I have one question here from Night Nights on Facebook, who says, I'm in a union, work for a university. I don't want to get vaccine. Options. So as a unionized worker, you're in a different legal landscape than the private industry where you're not unionized. So there are different rules that are going to apply simply because as a unionized employee, you have to go through your union. So you can't have an employment lawyer represent you. You can't, sue your employer in court or have any issues resolved from a legal perspective in court. You have to go through your union and file a grievance. And so when it comes to vaccine issues or policies in a situation like yours, it's going to have to be an issue that's dealt with through your union. And so in terms of what your options are, it'll depend on the circumstances. It'll depend on what you're in a university, so it'll depend on what your position is. It'll depend on what your union says. It'll depend on all sorts of different things. Some unions have encouraged mandatory vaccine policies, and others have come out and expressed that they're going to be fighting mandatory vaccination. And so it just depends on what your union has done. If you have an issue where there is a mandatory vaccination policy in place or about to be implemented, and you're not going to be vaccinated, you should speak to your union, and you should do it right away because they will be able to advise you on what your options are, whether they're going to assist with filing grievances, what their position is, and so on and so forth. Because right now, we are essentially in a situation where it's going to be a case-by-case basis, depending on your job, depending on your industry, depending on your union, especially for unionized workers. So that's my best advice to you is speak to your union immediately and find out what your options are through your union, because as an employment lawyer, I can help employees who are not unionized, but I can't assist you if you are unionized in this issue. So I have more questions coming in here. Rachel on Facebook says, my work just said they're going to mandate the shot. What can I do because I'm not interested in getting it at this time? Good question. So I'll probably repeat myself a lot during this session because every situation is different and it requires an analysis of your exact circumstances. So when it comes to the vaccine and whether an employer can implement a policy and whether you have to be accommodated or not accommodated, whatever the case may be, will always be fact specific. So there is no rule of thumb, one size fits all. It's going to change from one individual situation to another. And that's why it's so important to make sure that you're getting advice from an employment lawyer before you do anything. Because if you do act, you may make a mistake, you may misstep, you may prejudice your legal position, which is very hard to come back from in most cases. So if you are in a situation like you've done today, Rachel, ask the question. But again, I don't have all of the information. So it's very difficult to say what you particularly should or can do, what your employer should or can do. But what I can say generally is if you're not going to get the vaccine, or at least not for the time being, which you've mentioned in your message, speak to your employer. Depending on the industry you're in, there can likely be various accommodations available. You may be able to work remotely. You may be able to social distance and wear a mask, and there may be COVID testing available. There's all sorts of options that are at the disposal of employers in order to accommodate employees where a mandatory vaccination policy has been put in place and you're either unable to get vaccinated for medical or religious reasons, or you simply do not want to get vaccinated for personal reasons. There should be a whole slew of accommodations that could be available to you depending on the situation. So open that dialogue up with your employer, have a discussion. That is the absolute first step. Have the discussion. Figure out if there are, accommodations, workarounds, what can be done in order to accommodate you not getting the vaccination. And again, it will be fact specific. Some industries and some positions will be easily accommodated in this type of situation. Others might be more difficult. But that's why the first step is to have that discussion with your employer so that you can see where is it that you can go from there. Because it doesn't necessarily mean that you're automatically going to be fired or terminated from your position because you didn't get the vaccination. From what we're hearing from most employers, it's a balance that is being attempted to be found here between health and safety and keeping on employees and not having to lose good employees. So most employers should be open to that discussion and that dialogue and the essentially investigation into what else can be done here aside from this mandatory vaccination. So that's, Rachel, really where you should start and go from there. And, if you're in a situation where there is no accommodation available for whatever reason, then get back in touch with us and we'll assess the situation for you and see what your options are at that point. I have another question here from Beverly on Facebook, who says she works at a hospital with November 7th mandate, disciplinary action and or termination. What can I do? So what I understand from Beverly's question is Beverly works at a hospital and the employees at the hospital have a deadline of November 7th to get vaccinated, failing which they may be subject to disciplinary action up to and including termination. Let me know, Beverly, if I don't have it right, but that's what I glean from your question here. So if you work in a hospital, the first kind of red flag that comes up for me is you may be unionized. So similar to what I was discussing before, if you are unionized, you'll have to go through your union on this issue. And again, see what their position is on it. Are they going to be fighting it? Are they going to be encouraging it? Are they going to be, advocating for their members or employees who are not getting vaccinated? So you'll have to speak to your union if you are unionized in a hospital setting. If you're not unionized from a private practice or private industry, I should say, perspective, it's again fact specific. So we have had people that have gotten in touch with us who are in very similar situations to you, Beverly, where they've received a written notice that says you have to be vaccinated by this date, otherwise you will likely be terminated or you will be terminated. If that's the case, then you should get in touch with myself or any of our lawyers right away. We'll look at the situation for you, we'll assess it, and we'll be able to tell you where you stand. So you can actually email us at help@employmentlawyer.ca, and we will be able to get back to you because we will have to know your exact set of circumstances, your position, again, assuming you're not unionized, your position, the hospital's exact policy, the reasons for why you won't be vaccinated or you don't want to get vaccinated. All of these things will differ from one situation to the next, and it will affect the legal analysis. So definitely get in touch with us and we can let you know where you stand. But in general, in terms of a termination because of a refusal to get vaccinated, that's a real slippery slope for the employer, and they definitely would be exposing themselves to liability for at least severance pay, as well as potentially human rights damages, depending on the situation. And so you're not in a situation where if, let's say, your employer does let you go because you don't get vaccinated, it's not a situation where that's it, that's all, there's nothing you can do about it. There is something you can do about it, and you are owed certain damages and severance pay. And so if that does happen, definitely get in touch with us right away. You can email us, like I said before, help@employmentlawyer.ca is the email address. You can also go to our website, which is employmentlawyer.ca, and you can contact us in that way as well. All of our lawyers' contact information is available on our website. So if you go to employmentlawyer.ca, you can contact myself or any of my colleagues to assess your specific situation and let you know where you stand. And so, Beverly, I would suggest if you're not unionized, you do get in touch with us so that we can figure out how best to assist you here. All right, lots of other questions coming in. I have a question from Stacy on Facebook who says, I am a healthcare worker and mandated to do a learning module. The issue is they're asking inappropriate questions. Have you been vaccinated? If not, what is your reason? I contacted the union and they state that it is not a violation to ask these questions. What is your perspective? My union is taking the stance that everyone should be vaccinated. Okay, so a perfect example of what we were just talking about, which is a unionized employee where a union is saying that everyone should be vaccinated. So in a situation like that, it's a really tough situation. To be quite frank, when you're unionized, you are limited in the sense that you can't go through a private lawyer. You have to go through your union. So if your union is supporting the mandatory vaccine policy, you are kind of stuck between a rock and a hard place, so to speak. In terms of your questions, the questions that they're asking you, you don't have to provide privileged medical information to your employer. So whether or not you're going to be vaccinated and what the employer's policy is and what they might do as a result of you not getting vaccinated, that's one issue. But in terms of, the reason, you don't have to necessarily provide the reason. Why you might want to, but you don't have to, is with respect to accommodation. So if there is a religious reason why you are not choosing or you can't get vaccinated, or a medical reason, then that should be disclosed, because the employer has the duty to accommodate you for any ground that's protected under the Human Rights Code. They also have a duty to accommodate you with respect to you choosing not to get the vaccine. And so when it comes to the reason, depending on what the reason is, it may be relevant with respect to accommodation and you may want to disclose it. But again, you don't have to. That's if it's medical, especially, that's private information. And in terms of the status of your vaccination, again, private information that you don't have to share. In terms of, not getting vaccinated, you will have to have that discussion with your employer. I hate to sound like a broken record for everyone that's watching, but it is, again, fact specific. So for you specifically, Stacy, we'll have to assess what is your position, what is the situation. As a healthcare worker, there's a whole variety of positions and workplaces that you could be in. And so all of these different things will impact what your options are. But essentially, as I mentioned, with the last question, at the end of the day, if you are terminated because you are let go, you are owed severance and potentially human rights damages. As a unionized employee, with respect to that issue specifically, unfortunately, we can't assist you with that because, again, you'll have to go through your union and file a grievance with respect to any severance owed. For human rights issues specifically, most of the time you do have to go through your union. Sometimes a union will consent to have you hire a private lawyer and have a lawyer represent you for that issue. So those are just possible outcomes of what could happen. But hopefully that information is helpful to you in terms of moving forward. But again, every case is different. So if you're not sure what to do here, Stacy, get in touch with us. Because you're unionized, we're limited in how we can assist you, but certainly we can always provide advice. Okay, so we'll move on to the next questions. I have a question from Anne-Marie on Facebook who says, I'm a manager and have a notarized religious exemption. Can they refuse it? So specifically for religious exemptions, if you aren't able to get vaccinated because of your religion, your religious beliefs, and it is a recognized religion, then there is absolutely a duty for the employer to accommodate that. So if you are in a workplace, Anne-Marie, where they've mandated vaccines, but you are unable to get a vaccine for religious reasons, and as you've mentioned, you have notarized religious exemption, you have perhaps documentary support, which isn't necessary, but it is helpful, then once you provide that to the employer and you disclose that religious belief or religion to the employer, that then triggers their obligation to accommodate you up to the point of undue hardship. So what that means is, as long as the accommodation is possible, which in most cases it is, they have to accommodate you. So to answer your question, no, they can't refuse it as long as it's possible. I can't frankly think of a workplace where no accommodation whatsoever is possible when it comes to the vaccine. Maybe in, maybe a warehouse setting, it might be difficult, but notice how I say difficult and not impossible. And so the employer in a situation like what you're describing, Anne-Marie, has an obligation to investigate and figure it out rather than just say an outright, no, we can't do this because it might be inconvenient or difficult. They have to look into it and they have to find a way to accommodate you, again, as long as it's possible, which it likely is. And so the employer should be taking those steps once you've disclosed this to them in order to find a suitable accommodation for you. As I mentioned before, there's many different types of accommodations here. It depends on the workplace, depends on your job, but one such accommodation could be remote work, working remotely. Another one would be social distancing, wearing a mask, of course. You may be, put in a different area of the workplace where you're more isolated. There's so many different types of accommodations that are possible. It does take a thinking process about it, an inquiry process, and figuring out what that might look like. But those efforts on your employer's part definitely need to be undertaken. Otherwise, they are not fulfilling their duties under the human rights legislation. So you can push back on that, Anne-Marie. You can let them know that they have a duty to accommodate you up to the point of undue hardship. Feel free to let them know that you've received legal advice and see if they will agree at that point. If they ultimately refuse to accommodate you, get in touch with us, get in touch with me. I'd be happy to help you because there is, like I said, almost no reason for why they can't accommodate you, depending on the reasons and what's possible. But in most cases, it is possible and they should be doing it. I'm going to move to the next question here. I have a question from 91RSS on YouTube who says, my friend is fighting a loss of benefits as they turn 65. They're hoping to win as there are others there in the same boat. So I'm not quite sure what the question is here, but what I can say is if what you're talking about is health coverage, health benefits, health and dental, a lot of the time that's provided through employment, those specific policies that are created by insurance companies often do have an age limit. Same for long-term disability benefits or short-term disability benefits, for example. Those usually, and I'd say always, not usually, have an age limit. And that's in the policy from the initial creation of the policy. A lot of the limits are 65. Sometimes it's 70. That's usually what we see, 65 and 70. And if that's what the policy says, then this issue has actually gone to court and been found to be non-discriminatory. So what that means is it's not that they're treating one particular 65-year-old or 70-year-old differently. It's the whole category, and it's with respect to the policy itself. It's not an arbitrary decision. And so in that situation, unfortunately, even though it is technically a form of age discrimination, what the courts have said is that from a legal perspective, it isn't an unlawful type of discrimination because it is kind of a policy-wide issue. So I hope that information is helpful to you. I have another question here about religious accommodation from John on Facebook, who asks, what are religious accommodations in Alberta for vaccination exemption? The accommodations will differ from position to position. So there is no kind of mandated accommodation. There is no type of accommodation that's recognized by the law. It's between the employee and the employer to work together for that accommodation to occur. So the first step is letting your employer know that, for example, in the vaccine context, you can't get vaccinated for religious reasons. Then that triggers their obligation to accommodate you, again, up to the point of undue hardship. And that's when you would move forward in terms of what types of accommodations may be available. So there is no, right or wrong. It's all just a question of what fits in terms of the specific workplace setting, the employee's position, whatever the case may be. So, it's sometimes takes a creative accommodation. When it comes to these vaccinations, it's not so creative. I've talked about them already in terms of what are the types of accommodations. It's kind of the standard ones you would think, working remotely, mask, social distancing. Those are all the accommodations that would be the standard ones. But the sky's the limit in terms of accommodation. So it's whatever works best for the situation. All right. I'm just scrolling through the questions. We have a lot here, so I'm just trying to get to them all. All right, I have a question here from Christine G on Facebook, who says, what about weekly testing? What if we're against that? Which is a very good question, one that we're getting a lot, because one of the accommodations that we've talked about today is testing. So a lot of workplaces are offering an option where it's a mandatory vaccine, or alternatively, you can submit to weekly, monthly, whatever the case may be in terms of frequency, but testing instead. Now, it depends on your workplace, your industry, again, whether you're unionized or not. We're going to start to see, I think, this issue specifically get addressed by the courts. What I can say is there have been a couple of cases in the healthcare setting that have already come out in a unionized setting where testing has been found to be reasonable, as well as mandatory vaccination, but specifically to the testing. That's something that in certain industries has been found to be reasonable as an accommodation. And so it depends on the reasons for why you would refuse the testing. If it's being offered as an accommodation to not getting vaccinated, it may be that the testing is too invasive, again, for religious or medical reasons. So you may be able to refuse it on those bases and have an accommodation required there. But otherwise, it would depend on the setting. In most situations, if testing is being offered as an accommodation and it is in the pursuit of upholding health and safety within the workplace, and I should add, the employer is paying for it, then it likely will be considered reasonable. Again, depending on the circumstances. I will add, we've had a few people contact us with respect to testing policies being implemented where the employee was being asked to pay for the testing out of their own pocket. That is not acceptable. That's not okay. An employer cannot force you to do that. But if the employer itself is taking care of the testing, having it on site, paying for it, that is different. So I have a question here from Jamie Lee on Facebook, who says, my husband's employer is asking for a doctor's note for medical reasons for not being vaccinated. However, they've known his conditions for the past 5 years. Don't they have the duty to accommodate without a doctor's note, or is one absolutely needed? Good question, one that we get a lot. A doctor's note is needed. So in terms of any time where an accommodation is required, specifically for medical reasons, whether it be right now, what we're all dealing with, which is the COVID-19 vaccine and mandatory policies, but even if you're dealing with an accommodation required, let's say you have to have your hours reduced because of medical reasons, or you have to work less days, or you have to adjust your duties for medical reasons, whatever the case may be, anytime you require an accommodation in the workplace for medical reasons, you have an obligation as an employee to provide a medical note. Some employers will not ask you for one. Some of them will just take your word for it and accommodate you, which is always nice, but they don't have to from a legal perspective. From a legal perspective, their obligation to accommodate is only triggered once you provide that doctor's note. And so for your husband, Jamie Lee, he does have to provide, especially for this type of accommodation, he does have to provide a medical note. And if he can't get vaccinated for medical reasons and he provides a doctor's note, no issue there. Right away, the obligation to accommodate on the employer's part will be triggered and they will have to accommodate, again, up to the point of undue hardship, meaning as long as it's not impossible. If it's possible to accommodate, he will have that accommodation, or he should have that accommodation. But on his end, what he needs to do is trigger that obligation by providing that medical note. So we have a question from Fantania on Facebook, who asks a couple of questions about religious exemptions. So asking, what is the definition of religious reasons? Does the religion stated as base of vaccine refusal have to have an official statement regarding vaccination? So when it comes to religious reasons as the reason for why somebody is not getting vaccinated, as I mentioned a bit earlier during this session, it has to be a recognized religion. In terms of an official statement, it depends on the situation. So you wouldn't necessarily have to prove like you would with a medical reason with a doctor's note. But in terms of providing documentation, if you can provide documentation just to support the fact that you do have this religion belief, you are part of this religious group, that's helpful in terms of triggering the employer's duty to accommodate you. I have a question. This will be actually the last question because we're just getting to the end of the 30 minutes here, but I have time for one more question, and I have a question from Laura on YouTube, who asks, what if the workplace has decided to close on certain days of the week or close the day before stat holidays and books vacation for all employees to cover these days they are closed? Is this allowed? So in terms of vacation, and this is a very common misconception because most employers kind of work with their employees, or if you do ask for a vacation far enough in advance, it's approved without issue. But they don't have to. And how it works is the employer actually has the discretion to decide when you can take a vacation as an employee. It's not an issue that comes up very often because, as I mentioned, most of the time the employers are kind of happy to approve a vacation when it's requested, as long as it doesn't interfere with whatever's going on in the business. But ultimately, they can decide when you take vacation. What they can't decide is if you have vacation. So under the Employment Standards Act, there's a minimum amount of vacation that each employee gets to receive. For anybody with less than 5 years of service, it is 2 weeks. And beyond that, when you have more than 5 years of service, it's 3 weeks. That's the bare minimum. And that means you can take that amount of time off, whether it's paid or not, depends on the workplace's policy. It can be a paid vacation or it can be unpaid, but you accumulate either 4% or 6% off each paycheck. So either of those are fine, but it has to be one or the other. You have to be able to take your vacation. So it can't be that your vacation is denied outright for the year, but they can actually decide, or I should say an employer can actually decide when that vacation gets taken. And so in terms of booking, certain days as vacation days for employees, the employer is actually allowed to do that. In terms of your question about the stat holiday, depending on the situation, you would have to be paid. You always have to be paid for the stat holiday, but they can, pay you for the stat holiday and then have that be part of the vacation as well. So it just depends on the situation, but it can't be a stat holiday and a vacation day at the same time. So I hope that kind of answers that question, Laura. But if you have any follow-up questions, please feel free to contact me directly, and I can answer those questions for you. So we're just at the end of our time for today. So if I didn't get to your question today, we had a lot of questions today, understandably, because of the vaccine issue. So if I didn't get to your question, feel free to email us at help@employmentlawyer.ca or go to our website at employmentlawyer.ca. You can contact us in any of those ways. You can also call us, whatever works best for you, and we'll be happy to help you as best we can. Thank you all very much for your very good questions today. And I hope that everyone has a very nice weekend. I'll see you in the next session.